Welcome to Canadian Justice. I'm Christine Van Geyn. The Federal Court of Appeal has now ruled on the legality and constitutionality of the Trudeau government's invocation of the Emergencies Act. The Emergencies Act was invoked in response to the 2022 Freedom Convoy, which had protests that had blocked streets in Ottawa and border crossings in Ontario, Alberta, and Manitoba. The Canadian Constitution Foundation, which is the charity I work for, challenged the invocation of the Emergencies Act as unlawful and unconstitutional. And the Federal Court of Appeal has now sided with us and upheld the federal court decision, finding the same thing. The Federal Court of Appeal decision will restore the Emergencies Act to what Parliament intended, a narrow and exceptional tool. This creates a precedent that will bind future governments and prevent abuse. Once the Emergencies Act was invoked, it had been used by Prime Minister Trudeau to ban protests nationwide, freeze bank accounts, and share personal financial information with police without warrants. Here today to discuss the decision are two of the lawyers who were involved in the case, Sujit Choudhry, who represented the CCF in Federal Court of Appeal, and Josh Dehaas, the CCF's new litigation director. Thank you both so much for joining me today. And first off, congratulations to both of you and to me on this incredible victory. And thank you for doing such an excellent job. And first, I just want to get both of your high level reactions to the appeal decision. Sujit, we'll start with you.
It was a thrill to read. It's incredibly thorough, comprehensive, scholarly, very principled, and is kind of unrelenting in its criticism of the federal government's invocation of the act. So we couldn't be more pleased with the decision.
Josh, how about you? What's your high level reaction to the appeal decision?
Well, for me, this is a generational win for civil liberties as well as the rule of law in Canada. The judges did exactly what they're supposed to do here, which is carefully examine the act, put aside the politics and some of the emotions surrounding this issue, and just focus on the law. And the result of this is that civil liberties will be better protected for generations going forward.
Now, I think the way I think about the case is sort of two big, broad categories. First, was the use of the act justified? Was the threshold to use it met? And then the second category is were the regulations constitutional? So let's start with the first category, which is whether the threshold to use the act was met. Trudeau had proclaimed what's called a public order emergency, and that has a specific definition under the act. Sujit, what is required to proclaim a public order emergency?
So the act was very carefully drafted to make it hard to use. That's the background to the question, and the reason that matters is that the definition of a public order emergency is very technical. So it requires that there first be a situation that rises to the level of a threat to the security of Canada, or what we call colloquially a threat to national security. And second, that the situation be so serious as to be a national emergency. And by that, the act requires that the emergency be beyond the capacity and authority of a province to deal with, and that no other law of Canada be sufficient to address it.
And the thing that is incredible is that none of those were met in this case. Let's go through some of them. The first is whether or not there was a threat to the security of Canada. And this is a term that's defined with reference to the CSIS Act. Josh, can you briefly explain why there was no threat to the security of Canada as is defined in the Act according to the Federal Court of Appeal?
Well, the definition in the Act, the CSIS Act, is very clear. It gives you a short list of types of threats that could count as a threat to the security of Canada. Things like espionage or sabotage, things like threatened insurrections, and using serious violence to achieve political, ideological, or religious aims, which we colloquially call terrorism. And it was this one, terrorism, that they pointed to when they invoked the act. And the court said, no, these activities, they do not rise to the level of threats to the security of
I
Canada
think the
in the form
court
of
said
terrorism.
the court said it might have been annoying And of course, annoying is not the same thing as serious physical violence. We're going to discuss this further when we come back from this commercial break.